Good day and welcome to an interview with a very important figure in Arizona state politics. The gentleman we're going to talk to today served as our Attorney General, our Superintendent of Public Instruction. He was the chairman of the board of the Paradise Valley School District. He's a successful lawyer. He comes from Harvard, where he won top honors. My name's Bill Williams. I'm just a journalist. But let's welcome Tom Horne to our group.
Thank you. You might have also mentioned that I was a judge pro tem, both in Superior Court and the Court of Appeals. So I served in all four branches of government: local, legislative, I was in the legislature, executive, superintendent of schools and attorney general, and judicial as a judge pro tem.
We want to talk about an important case that landed in the lap of Yavapai County Attorney Sheila Polk. It came out of Maricopa County. Sheila Polk was assigned to your case, and she ordered you to return $400,000 in donations to Business Leaders for Arizona, which Polk said illegally coordinated with your 2010 campaign.
Yeah, it was a false charge, and it was been proven in court it was a false charge. In fact, it was proven twice that it was a false charge. When she first brought the charge, it went to an administrative law judge. The administrative law judge found in our favor, Kathleen Wynn's favor and my favor, and against Sheila Polk. Sheila Polk purported to be able to overrule the administrative law judge, even though she was the prosecutor of the case. It's a civil case, not a criminal case, but she still prosecuted the case. She purported to have the power to overrule the administrative law judge, who found in our favor, to find in her own favor. She lost the case, she didn't want to lose it, so she says, well, I'm going to decide that I won it all by myself. The Arizona Supreme Court said the following: specifically, we hold that when Polk also assumed an advocacy role during the administrative law judge proceedings, the due process guarantee prohibited her from then serving as the final adjudicator. In other words, she violated the Constitution. Now, the Arizona Supreme Court did not determine the merits. They sent it to the Attorney General, and the Attorney General in turn sent it to the Cochise County Attorney. The Cochise County Attorney was the final determiner, and he came up with the identical conclusion that the administrative law judge came up with, that she had brought a false charge, that we had not coordinated. And this is what he said in his final order. She had used an FBI agent. The FBI's inaccurate and misleading summary of the conversations with Mr. Tatham, that was a witness, and subsequent inaccurate testimony regarding the same calls into question the reliability of other hearsay statements offered. The record unfortunately supports a conclusion that the investigation being conducted was not a search for the truth, but rather only intended to shore up conclusions already drawn. He read the entire record, it was several feet high, and he came to the conclusion that the administrative law judge was correct and that we were not guilty, that we had not coordinated, and that Sheila Polk had brought a false charge. So I turned around and I sued her for violating our constitutional rights. She said, and that was in federal district court, and she said to the federal district court, I should be immune because I'm a government official, and if I make decisions in good faith, I'm immune. Well, the district court didn't agree. Here's what they said. The defendant, in this case Sheila Polk's, participation as both a prosecutor and adjudicatory authority for the administrative action is the exact opposite of the fairness, independence, and impartiality becoming of a judicial or quasi-judicial authority. The court finds that a reasonable official in the defendant's position, that's in Sheila Polk's position, a position that is synonymous with legal training and advocacy, should have reasonably understood that serving as both a prosecutor and a final adjudicator for the same case would violate a defending party's due process rights. The defendant had to have known that it was improper for her to reverse the administrative law judge's decision, that was the administrative law judge's decision in our favor, for a matter in which she was deeply involved as an advocate and prosecutor. Due process rights are among the earliest and most basic legal concepts attributable to the study of criminal and constitutional law. And the defendant, Sheila Polk, should have understood that her participation in overruling the administrative law judge's decision was improper.
I remember some verbiage that came out of that, and I'd like you to expound or explain. I remember seeing she was labeled by the court as the accuser, the advocate, and the final decision maker.
Right.
What's wrong with that in terms of a legal position?
Well, it's fine in totalitarian systems. In the Soviet Union, if the prosecutor accused you, you were guilty. Didn't matter what an independent judge would say. But not in the American system. In the American system, you have an adversary proceeding and you have a neutral judge make the decision. You don't have the prosecutor both do a prosecution and make a decision. That's abhorrent to our judicial system.
For the viewers or listeners who might not know the background, let's take a step or two back. This was about Polk's theory that you and Kathleen Wynne coordinated on an advertisement saying negative things about your opponent, Felicia Rodolini. Rodolini was on record as saying, I don't want to talk about that. Let me tell you about my qualifications. So even the Democrat candidate didn't want to go there. So what was wrong with Polk's theory?
It was totally false. Kathleen Wynne and I did not coordinate. We never discussed what she was doing. She was running an independent campaign. Independent campaign means the candidate has nothing to do with it. She knew that. I had referred her to a lawyer who was an expert in elections law to coach her on that. And the fact is that we did not coordinate. And the administrative law judge found both of us to be credible. And as you heard, the main witness that Sheila Polk presented was an FBI agent who perjured himself. He claimed to have had a conversation with a witness. The witness recorded the conversation and came to court and played the recording showing that he lied. So the FBI agent then said, well, it was a later conversation. So the same witness came in with his telephone records to show there had been no later conversation. And that was why both the administrative law judge and the Cochise County attorney who made the final determination pointed out that the FBI agent who was working under Sheila Polk as the prosecutor had perjured himself, and that this whole thing was not a search for the truth. It was designed to support pre-existing ideas.
Now, from a taxpayer or a journalist point of view, this was a long journey for you. Originally, Maricopa County Attorney Bill Montgomery had released his findings in 2012, and then a judge threw that out on legal and procedural grounds, correct?
Mm-hmm. Yes.
And then it got connected to the Secretary of State's investigation, and all of a sudden Ken Bennett says, whoa, this is complicated, I'm sending it to Sheila Polk. Do I have this right? So
He sent it to the Attorney General's office. I was Attorney General at the time, so I obviously had a conflict of interest. So it went to the Solicitor General, who works in the Attorney General's office but is somewhat independent of the Attorney General. And it was the Solicitor General who sent it to Sheila Polk.
now, correct me if I'm wrong, but maybe one of the true things the FBI agent said under oath was that he found no evidence of Wynne and Horne making a transaction. Is that correct?
If you say so, I don't remember that, but I believe you.
And then they talked about phone calls, and they said, well, we have phone records, and it looks like Tom was talking to people. And then as the evidence came out, it showed that they couldn't tell who was on what phone talking to who about what subject. Is that correct?
Well, I think where there was a problem was that Kathleen Wynne had a background in mortgages, and I had just sold a building and was buying another one. So I asked her for some help in that, and she helped me with that. So there were phone records showing we talked to each other, but we never talked to each other about the political campaign, and that was found by the administrative law judge and the Cochise County attorney. And the administrative law judge held a hearing and saw us testify. Sheila Polk never saw us testify. She claimed to be such a genius that she can sit back, have nothing to do with the hearing, and overrule the administrative law judge. And that is contrary to our system.
Even with the negative press attention from the once conservative Arizona Republic, they ran a quote saying, "You're the best retail politician in the state." I thought Jan Brewer was the best retail politician. What does it mean to be a good retail politician?
I don't remember that either, but I do remember a compliment they paid me when I was in the legislature. They said that I raised the level of discussion at the legislature all by myself, so I appreciated that.
Well, of course, we want to know where this goes from here. You know, we hear things from time to time that it's in the Ninth Circuit Court. Can you tell us where things stand now?
Yes. I read to you the decision where the federal district court judge had ruled against her, where she said she had immunity because she acted in good faith. He found that she should have known what she was doing was wrong. Any first-year law student would know that what she was doing was wrong. But then another issue came up, a very technical issue concerned with the statute of limitations. The federal district court judge ruled against us on that one, and that's at the Ninth Circuit. And the Ninth Circuit now is going to have to decide on that technical statute of limitations question.
Okay. Now, the investigation resulted, as you said, in no criminal charges, but a civil charge of illegal coordination. But that was later dismissed by the Arizona Supreme Court. So how did we go down this convoluted line so that you're having to defend yourself in the higher court?
Well, as I mentioned, we appealed the decision, and we appealed on the grounds that what she had done was totally contrary to our Constitution and our system of courts and trials and adversary proceedings, and judges who were present and saw the witnesses deciding who's credible and who isn't credible, and not somebody in her own office deciding she's such a genius that she knows who's credible or not without seeing the witnesses. And the Arizona Supreme Court agreed with us and held explicitly that she violated our constitutional rights. So if the Ninth Circuit rules in our favor on the question of statute of limitations and we go to court, most of the issues are already determined. The Arizona Supreme Court already determined that she violated our constitutional rights. The Cochise County Attorney already determined that she was wrong on the subject, that we had not coordinated. And so probably the only thing that'll left to be determined will be the damages.
Is it true that no board or commission ever reviewed what Sheila Polk did?
Well, the Arizona Supreme Court reviewed it, and the Cochise County Attorney reviewed it, and they both found that what she did was wrong.
But no peer group or board or commission was ever allowed to look into her actions?
No, but everybody that did review it found that what she did was wrong.
So what's next for Tom Horne? I heard that after you lost in 2014, you became a greeter at Walmart, but what's next for Tom Horne?
I went back to private practice. I'm suing people right and left. And if any of your listeners or viewers need to sue someone, they're free to call me. I'll be a good advocate for them.
Well, thanks for joining us today. And to our audience, we're going to leave this open to Sheila Polk. If she wants to come in and give her side of the story, she can. So stay tuned. We're going to have some more on this story as it unfolds. Thanks for watching.